Hello ladies and gentlemen, welcome back to Coin Lady channel. Yesterday, we received a surprising filing from Ripple in the SEC versus Ripple case, and it's possible that this is the last thing sub ever submitted by Ripple. This is a supplemental filing, and the fact that we are so close to, probably, the end of this case is what prompts me to say that I feel compelled to inform you of this development. It's a brief update, but hopefully helpful. Anyway, I heard back from a few community members, including David Schwartz, with their thoughts on this. Jeremy Hogan, an attorney, and John Deaton, also an attorney, have contributed materials. But I do want to clarify something before we go any further. I come from no financial or legal background. Do not buy or sell anything based on anything I say or write. I'm not a licensed attorney or financial advisor. I'm just a fan who occasionally posts videos to YouTube about random crypto-related topics for kicks. After covering this story for over 2 years, it's strange to think that this video could be the final update before the story comes to a close. Feel some emotion of longing for the past. Okay, then. As a result, this company's legal battle with the U.S. Securities and Exchange Commission has been further complicated by the filing of a letter of notice of supplemental authority to Judge Annalisa Torres in support of the company's fair notice defense. Notably, in Binance US' most recent supplemental authority filing, the blockchain payments company cites Judge Michael E. Wilder's decision in the Voyager bankruptcy case to overrule the SEC's objections to Binance US bid for Voyager assets. This was disclosed yesterday by defense attorney and former federal prosecutor James K. Phelan, who has been following the case closely. Because of this, I'm assuming that everyone will remember that Voyager was one of the organizations that failed due to the pandemic last year. Moreover, Binance US has recently been trying to acquire these assets, but the SEC has thrown a tantrum, leading to a rocky start. So, in any case, look at this. Moving forward, it's not shocking that the XRP community has responded quickly to the most recent filing. Remember that in the recent ruling, Judge Wills blasted the regulator for adding to the already substantial amount of uncertainty in the young market, as was highlighted in a prior report. Chief Technology Officer of Ripple David Schwartz responded to the latest development by calling the SEC's actions outrageous. The judge criticized the commission for not intervening earlier in the case, as Schwartz pointed out. And in a subsequent tweet, the judge voiced his or her shock that the SEC would seek prosecution against parties who merely obeyed the court's order to complete a transaction. Guys, just consider this for a second. A judge has ordered you to take action. When people comply with a court order, an SEC wants to bring criminal charges against them. That's not a very solid foundation on which to build. The SEC's arguments for why this might be the case were too nebulous and unconvincing for the court to rule on, so let's say the piece continues. It's possible that the SEC is putting itself ahead of consumers once again. In order to decide whether VGX, Voyager's proprietary cryptocurrency, is similar to Binance or BNB Coin, the agency asked the court to postpone further proceedings at the expense of consumers. However, the agency claims it needs more time to decide whether VGX is a security and whether Binance US is an unregistered security exchange, despite the fact that the amount of assets users could recover due to legal fees would continue to decline in the meantime. The judge, thankfully, was not having any of it, and I was happy to report the news when it came out because it meant that real people would be harmed financially and psychologically by the looming threat of legal uncertainty. And, of course, so that the SEC could theoretically decide that the VGX token is a security. Having said that, let me move on to what David Schwartz has to say about this. On Twitter, he shared the following message with attorney Phelan. To be clear, the justice in question is only the Department of Justice, which is demanding that it not be barred from bringing criminal charges against individuals who comply with a judge's order even though it has not presented a convincing argument that the order itself is unlawful. Golf applause for David Schwartz. Indeed, you've hit the nail on the head. Furthermore, Jeremy Hogan, an attorney, said this. He reported that Ripple had completed the TRIPS paperwork. A judge's ruling on the Voyager bankruptcy, to be precise. The judge uses unusually strong language, saying that U.S. regulators themselves cannot even agree on what criteria to use in deciding whether crypto is a security. It seems like we're on the home stretch now. Maybe you're wondering what this has to do with Ripple. So, Attorney Deaton scores another home run, and here's a splashy headline from the cryptocurrency world. Basic Deaton discusses the implications of Ripple's most recent SEC filing. And I wanted to get down here and I think. Well, here we go. In a Twitter thread yesterday, Deaton commented on the filing and suggested that Judge Analisa Torres could use a recent ruling from her colleague in the Southern District of New York to criticize the SEC's actions and the perceived inconsistent treatment of digital assets. Keep in mind that the founder of the crypto law had previously stated, referencing the same ruling crypto law, that judges would be compelled to call out the Commission for its perceived lack of allegiance to the law, overreach, and inconsistent statements. In addition, the lawyer claims that the judge is less likely to find in favor of the SEC in its charges against the executives of Ripple. Keep in mind that the complaint lodged by the regulator included the names of Brad Garlinghouse and Chris Larson, who were accused of aiding and abetting in the sale of securities without registration. According to earlier reports, Deaton had called this action a mistake on the part of the market regulator and pointed to the most recent filing as evidence. Judge Torres is unlikely to find the executives guilty, according to Deaton, because the SEC was aware that XRP was an unregistered security. The following post from the thread he was quoting was then cited. Judge Torres of the United States Bankruptcy Court for the Southern District of New York, the same district as Judge Torres in the Voyager bankruptcy, issued a ruling yesterday that Attorney Deaton said he hoped Judge Torres was already very aware of. Ripple cites the decision as supporting evidence for the validity of its fair notice claim. Judge Torres can use the Voyager ruling as supporting evidence if she criticizes the SEC's approach and inconsistent behaviors/attitude towards digital assets in the current draft of her decision. Over a year ago, I predicted that Judge Torres would side with Brad Garlinghouse and Chris Larson. I expect Judge Torres to rule that the two executives did not act recklessly in failing to recognize XRP as a security, when the SEC wasn't so spot on by its own standards. And yes, it is speculation, but I think it's pretty healthy and reasonable speculation here that the judge might be writing something along those lines criticizing the SEC, because, look, she doesn't have a personal dog in the fight. I know I've said it before, but it bears repeating, this is the case. The contradictions are obvious to anyone with a modicum of objectivity and intelligence. Clearly, the SEC is taking a cautious approach to this whole matter. There is a lot of chaos in the market right now. So the idea that Judge Torres, who has no personal stake in the outcome of the dispute, would come in and criticize the SEC in this way is not exactly, a stretch of the imagination. They also shouldn't think it was a mistake to bring charges against Garlinghouse and Larson. Because of the Voyager case, Judge Wiles has gone after the SEC and been berating them, and it's about time. And this is where we are now, where it is once again abundantly clear that not even the SEC knows what it is doing. Therefore, it only serves as an additional source of authority. Ignobly cruel. Actually, the timing is perfect, as we are now in the final stages of the SEC versus Ripple case. I'd give that an 8 on a scale from 1 to 10. It will be interesting to see if that turns out to be the case when Judge Torres issues his ruling, or if he uses similarly predictable language. And now we have another piece of evidence to use to show that it's not just Judge Torres making these claims. And other judges are going to be dealing with SEC assets in other cases. And it's becoming increasingly obvious that they aren't changing their ways of being inconsistent. That sums it up nicely. Thus, we should anticipate some exciting developments. But now we're really getting close to the end. Also, I'm ready for this to be over with already. Who can say then? I mean, unless it takes a lot longer for Judge Torres to submit the ruling, we're thinking here that this might be the very last update I have from a legal perspective. For this case, in terms of new developments, this really could be it. However, one can never say for sure. There is the possibility of other events. Furthermore, if she delays filing this document and it doesn't happen in March, you can be sure that additional supplemental filings will be possible in the future. Since I'm not a financial expert, I have no idea what we should do. Nothing I say or write should be used as a basis for making any financial decisions. It's all over today. Please like and subscribe my channel. See you later, bye.